Please, the court.
Yes, sir.
It's been a long week, hasn't it, everybody? And I appreciate y'all being here. I appreciate your attention. I know it was an arduous event. All of us sitting here listening through that, all of the breaks at the bench, all those interruptions, it can be very annoying. It can take a lot of time. It's very distracting, but those things have to happen. In the voir dire, you'll remember, I stressed to y'all extensively about the Constitution. This is something we don't take for granted in a criminal case. Some people may want to downplay it. Some people may want to compromise our rights, the responsibilities, and the privileges that we have. They can't be. They cannot be compromised in the slightest event. This is a privilege we have. It's a constitution that is endured. It was created by hardship for men and women like us to live under the system we have. This system goes, we'll never have it back. We will never get it back. And it is at jeopardy at this stage. I told you that the founding fathers in this Constitution, they recognized that liberty comes with an extreme price. To deprive somebody of liberty comes with a lot of responsibility. Not coming in here, throwing a bunch of mud on the wall and saying, yeah, there you go. Oh, she lied about this, or here's another misstatement, or here's another misstatement. Laurie Shaver is not on trial for lying. Laurie Shaver is not on trial for bank fraud. Think about that. That the state has the audacity to come in here and state money's moved, thus she committed a murder. Guns were sold, thus she committed a murder. There's a car in the yard and a misrepresentation, somebody went somewhere, thus causation. That's a huge leap, an extreme leap. Remember we spoke about in voir dire, and I kind of used an example, and I said, I had seen on TV about, and I believe it was Joe Rogan and Jordan Peterson talking about, I think it was Rogan talking about, and he said, I see photos and stuff and talk about UFOs. And he said, and I hear this, and I hear this, and I hear this. He goes, I really would like to believe in UFOs. And he says, but, there's just not enough to put it all together for me. And Jordan Peterson said, yeah, that's a conspiracy theory. What does the state put together here this week? A conspiracy theory. She lied about this. Here's a misstatement. Here's a misstatement here. Here's a misstatement there. She must have murdered the guy. Think about that. Think about the draw and the stretch that the state has put out. Well, she had a motive. All right. That's a big stretch. Okay? I want to talk about the law foremost, and then we'll go over to some facts. And I'm going to show you, undisputably, irrefutably, how more than one reasonable doubt exists in this case. And we know what your responsibility is, and I just ask that everybody abide by it. In the instructions, it talks about, yes, what are the elements of a homicide? When the killing, excusable homicide, now we're talking about. When the killing's committed by accident or misfortune, was Michael part of his own misfortune? Obviously. 2, when the killing occurs by accident, misfortune, or in the heat of passion, Michael brings on his own death. Michael comes to the house when the state never established his right to be there. We know there were injunctions in place periodically. 3, when the killing is committed by accident or misfortune resulting from a sudden combat. All right. The state wants you to believe Laurie lied about this, or there's a misstatement here, or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my voir dire, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. Second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead. Yeah, we know he's dead, okay? The death was caused by the criminal act of Laurie Lee Shaver, okay? Has any single witness taken the stand and shown you one piece of evidence that established Laurie Lee Shaver killed Michael Shaver? Zero. Zero. Case over. Period. What they've done is brought in a bunch of digital data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamra Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA, do you? No. You don't have any prints, do you? No. You have nothing in the scene in the house to suggest any activity, do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you? No. You don't have any witness, do you? No. She admitted all that. And then her response was, well, how could we solve a murder any other way if we had to have all that stuff? Because you normally have that stuff if a murder has occurred and it's attributable to one person. The state tried to compromise that obligation. Do you remember? Do you remember how? They said, hey, Mr. Camuccio said, you're not going to hold us to that standard like CIS that you see on TV, right? Trying to lower what you could expect to see in this case. You're right, he said that, because he knew he didn't have any evidence. So we wanted to mentally prepare you to get you ready to not see evidence. That's what that was all about. You remember his statement earlier as well? we talked about the burden of proof. You'll remember that. And I talked about it in voir dire, and I talked about it, and I said, it's kind of like a football field. I said, in a criminal case,
I'm going to object.
this is an analogy for closing.
Let's have a sidebar, please. Thank you.
Football field. And I said, look, if it was a civil case and the standard is beyond a reason, is by a preponderance of the evidence in a civil case, that's just tilting the scale, getting past kind of the center of the field. But in a criminal case where our founding fathers put the premium on liberty and the obligation on the state, I said it's the highest standard required under the law. You got to be on the end of the field down here. There's a high difference between this, which can't be downplayed in this case by the state throwing some mud on the wall and saying, oh, there was a lie here or there was a lie there. You see, the state can't compromise that. Go on a little bit. When we talk about depraved mind, and you hear that word, and you'll have a complete set of these instructions. You go through them at your leisure, need be. Okay, it says, an issue in the case is whether Laurie Shaver did not have a depraved mind, with that mind without regard for human life, because she acted in the heat of passion. Okay, on adequate provocation. In order to find that the defendant did not have a depraved mind, then it gives you some factors to consider. There must have been a sudden event that would suspend the judgment. B, a reasonable person would have lost normal control. Driven by blind or unreasonable fury, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act. Y'all saw these photos. Y'all know there were repeated acts of violence in that house. This was not a blind event that Laurie Shaver just stepped up for her child and said, I'm not going to act. They knew what was coming. And this is evidence that they knew what was coming. We had multiple injunctions that were filed with the court. Michael Shaver had been prosecuted in the past, and the state wants to sit here and say, hey, this was some blind event and she just murdered her husband. I'd like to hear an explanation for that. move on some. Let's talk, because the state's going to have the last word in this case. They always do. We don't have the privilege to respond to their last word. Okay? Let's think about this. She's charged with accessory after the fact as well as a crime. What are the elements of this offense? And let's think about it. They state that a murder in the second degree was committed by another. State has a real courage to announce who that another person is in the elements or in the information. They don't have the backbone to tell you here who the actor is, who the principal is. And yet they'll come into court and say Laurie did it. Then it says, after the murder, Laurie Shaver maintained, assisted, aided, or attempted to aid another person. Stop. Right there. We see and hear talk about money going into the bank or going there. Okay? Is there been any showing in this trial how any money was moved to assist, aid, or attempt to aid somebody in escaping detection of a crime? No. Laurie's using money to live a life, feed her kids, that the state can't not deny is marital money, equitable money, that she didn't have a right to touch it, anything like that. But it's all a pull for you. And then it says, and at that time, Laurie Shaver knew that the other person had committed murder. Okay, let's think about that. That's an important element as well. And I'll tell you why. If you have a right to self-defense, no crime has been committed if somebody dies. No crime occurred. So you'll have to assess, was there a right of self-defense? If so, no crime has occurred. 2, where was money being spent to aid detection for somebody who had not committed a crime? You see? Does that make sense to you? Under the justifiable use of self-defense, it represents, and I'll just highlight some of this for you because I want to talk about facts. It says Laurie Shaver was justified in using or threatening to use deadly force, or Isabel was justified in using or threatening to use it if she reasonably believed. Now we know the history in this family. That's undisputable. That's physical. That's not to be questioned. Was necessary to prevent imminent death or great bodily harm to herself. Okay? And then it goes on and tells you, well, what's the type of harm that they suspected would happen? Michael's trying to kill her, or he's trying to commit an aggravated battery. And then the instructions tell you what that is, what the elements of first-degree murder are that Michael's trying to do, or how he's trying to create another hard battery on her, okay? And that's spelled out in these instructions. Then the instruction will tell you as well that justifiable use of force is justifiable if Laurie or Isabel reasonably believe that the force was necessary to prevent imminent death, meaning that a murder, attempted murder on her, or great bodily harm. Has the state eliminated this defense? No, not at all. They want to throw mud on the wall and say, well, she lied here. She spent some money here. But they can't say first and foremost, She didn't have a right to defend herself, to establish that a crime even occurred. It's actually, listening to this case, I gotta tell you, I'm spun around listening to it. The judge is gonna give you an instruction because they've made an issue in this case out of this. And it's an important instruction because it kind of strikes a nerve in all of us. And it says this: you must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. Laurie Shaver could watch Jay Townsend shoot somebody and had no duty to call the police. Isabel would have no duty to call the police if she hadn't shot him or done anything. Okay? That's a fact. That's a law. The state will act otherwise. Like, no, they could have called 911. Why didn't you call 911? Again, we spoke about this in Board I. Let me grab it. Foremost, I'm going to say, excuse my handwriting, okay? Probably the worst penmanship in the state of Florida, if anybody. But anyway, the judge will tell you that a reasonable doubt, and they're in your instructions. I briefly spoke about it because this is very important. If there's one reasonable doubt, it is the requirement, the responsibility, the necessity of any and every jury to return a verdict of not guilty. Not guilty. How does it arise? From the evidence. It can arise from the evidence itself. It can arise because of the lack thereof in the evidence. It can arise by a conflict in the evidence. Those instructions tell you. And they further say that if your feeling is not stable, but one that wavers and vacillates, you got a reasonable doubt. You see? Now let's shift over to the facts and talk about some of those facts. One we spoke about, and I want to remind you, the burden of proof is entirely on the state. Ms. Shaver was not required to take the stand, expose herself to criticism, ridicule, or a misstatement here or there. That burden stays on the state. We know, in this case, it became evidently clear, and should be to everybody here, that Ms. Shaver was in a marriage that had gone bad. It was a case where children lived in an environment that, as Isabel said, it just became commonplace to see these things happening. My dad striking, forcefully, acting out on my mom, and she said, I soon developed an attitude of feeling a need to protect my mom. I soon just responded with a attitude of response trying to protect my mom. That's how bad it got. So she said on the day that this happened, she goes, she was kind of in shock, went to school and just kind of tried to put it out of her mind. And that's what happened. And yet the state, despite all this, wants to criticize that girl who's a victim in this case. Shame on them. This little girl is a victim of a house with continual domestic violence, and the state says, well, why didn't she get counseling? Why didn't she get counseling more? The state chose to ignore this girl. She was brought to their attention, as well as Mr. Ballou. Mr. Ballou had prior tensions with Mr. Shaver. That's why his name was mentioned. Mr. Townsend's name was given to the state. The state took no aggressive action to look into this case. I asked Tamara Dale, state talk to you about this? Did you make any efforts to go see her? Not ask Kelly Johnson, hey, if she wants to come by, why don't you just bring her over? I mean, is that investigation? That's not investigation. That's just saying, bring us some evidence. We'll maybe look at it. State was aware of the domestic violence in the house. They had evidence. They had prosecuted Mr. Shaver for a battery. They knew about it. Wilma Nichols gets up there on the stand and says, yeah, well, Michael's story at an earlier date and time was that his wife attacked him. I said, are you talking about the same incident where he was prosecuted and the state went after him? Well, yeah. Yeah, that had a lot of merit, didn't it? There was nothing contrived by Laurie Shaver and this minor child. Now listen to me. The judge is going to tell you, you had the privilege of believing all, some, or none of the witnesses' testimony. So if you find that there was misrepresentations by Laurie Shaver here or there or one way or another, okay, you can disregard those. You can say, I don't believe that truth. But again, whereas the state led you to believe that Laurie Shaver killed Michael Shaver, they haven't. There's no evidence in that regard. We know there was times when Michael was not residing at the residence. That wasn't contradicted. His former girlfriend gets on the stand and says, yeah, he was living at the hangar here and there. Laurie said, I let him in the house. There were injunctions. He was coming and going. Did the state offer evidence that there was not an injunction or he was not restrained from the house, not permitted into the house on a date specific when any homicide occurred? No. No. Now, let's shift over to, for a moment, to the digital data. That was interesting to me. Kind of interesting, okay? You got some guy at the sheriff's office, corporal, he had to advise me, that does some tech work out of there. We never heard his qualifications, any experience really he had. Okay, I heard a lot of arguments from him, but we heard Connor take the bench, a man that had been involved in I don't know how many trials, federal trials, trials everywhere. And he had testified in court with his special skills, and he spoke to us real clear and simple. And he said, now think about it, he said this, the IP records from Facebook, CenturyLink, etc., at a point in time they expire and don't tell you the physical address it's coming from. They may have IP logs, records, you see, but you don't know where it's coming from. It could be Starbucks, it could be overseas, it could be here or there. So the state, trying to throw some mud on the wall, says, well, look at these IP logs, look at this, look at this. But you know what? It doesn't tell you where it's coming from, any device, or any user. You see? That's a significant fact. So the state says, well, somebody sent this, and somebody sent this, and this went here, and that went there. That would create a lack of evidence, a conflict in the evidence as well. And it certainly would not create stability in the way in which you think about it. If Jeremy Townsend is sending some of these, he could be at Starbucks, he could be at his house, he could be anywhere. He could be in a driveway, and he certainly had a motive that can't be excluded. Now, this child wants to be the state disparages this child because she doesn't know it's state specific. She said sometime in the spring. She didn't say summertime. Mr. Camuccio went on and he said, now today, well, she said the spring and the summer, and that's not true. Mr. Camuccio's not presenting evidence here today, but some of his statements were not accurate as to the content of the witnesses themselves. You'll have to rely on your memory, the notes you've taken here. Now, there's a discrepancy exactly, precisely, in what Laurie said and what Isabel said. Isabel, I believe, says, and you have to rely on your memory, she made some statement to the extent Jay threatened to kill us or something of that nature. Laurie said he implied it or something to the children. There was a little discrepancy, but they got the message loud and clear, okay? Don't tell anybody or you guys are going to get in trouble and you're going to be harmed. So, one, she doesn't have a duty to report anything, and somebody's threatened her. She's been the victim, we know, of repeated violence. It kind of makes sense this woman doesn't want to come forward with that kind of threat against her. It kind of makes sense that Isabel is not going to school and wanting to tell everybody all about it as well. Now, let's talk about a little bit about this shooting. The state's made issue of this, and I want to bring something to your attention, and I hope you picked up on it in trial. We heard from Dr. Shaw, the medical examiner, and we heard several things. I did, and it was brought out through his testimony. One, he said there was a gunshot here to the rear of his skull, and we know that, okay? And I elicited testimony from him when I said there was no soft tissue on this body, correct? Yes. And I said, could it be that somebody shot through some soft tissue and that may account for the presence of the shrapnel? He says, yeah. And so you may have a bullet that goes in, exits an eye, and there's some shrapnel in that skull. I asked him, did anybody do any meteorological testing on the fragment together with the shell to see if they were linked together? No? Now, who's in charge in directing them to do these things? The state. Does that create a lack of evidence? Correct. Does it create a conflict in the evidence? Yes. Does it create stability in your mind? It shouldn't. Okay. Whose obligation is that and the burden rests with to come in here and prove these facts? The state and only the state. Now, one thing further I brought out through Dr. Shaw, and I know you all probably heard it. I don't know if you picked up on the significance of it at that time. But I asked him about injuries and the nature of the injuries that existed on this body. And I said, were there post-mortem injuries to the body? And he said, yes, there were. And he noted several ribs. And he said those were post-mortem injuries. And I said, when we talk about post-mortem injuries, how do you identify them? And he described about buccal fractures in the ribs and the way to identify it. And he said, this is where the body is broken after the death and there's a discoloration in the ribs here and there. And I said, could that be accounted for? And he said that can be accounted for by moving the body. I said, correct. So Jeremy Townsend logically tells Laurie Shaver, I'll take care of this. She understands they got property elsewhere, logically. That body disappears at that time. Now, when did the body logically and arguably show up? When, after that shooting, when Laurie said, it's over. It's over. Okay? She even took the stand, and I thought this was kind of sad listening to this. And after all the violence she incurred, she started crying and saying, I still loved Michael. So we know any relationship between these two was logically over. Now, maybe, and I don't know, we talk about flowers being sent, cards being sent. Was that sent by Laurie maybe to make sure Jeremy's not coming back? Maybe to get him in trouble with his wife? Possibly. You may interpret it that way. Now, we also heard from Mr. Cios, remember? And the state called him. It was their witness. And he said, I asked him this, didn't you call Laurie, advise her somebody was trespassing on your property? Yeah, she was gone, and I saw somebody trespassing. Who had any motive to come back to that property, deliver something back to that property, if it had been removed? Jeremy. You see? That fits together a little tighter. Now, talking about that gravesite, did the police think about the depth of the site, the height of Mr. Townsend versus Laurie Shaver? No. Never even analyzed that mentally. It's not that difficult to think about that. Okay? Also, there's a blue tarp in the grave. Right? We heard all about that. And I said this, and I don't know why this wasn't done. We had told the state about Jeremy Townsend. I said, did anybody do a financial audit of anybody's accounts to see who may have purchased a blue tarp? No. They should have. I'm telling you, if they had one on my client, they'd be in here waving it up in the air. It's her tarp. Lack of evidence, conflict in the evidence. I asked the officer as well. I said, did you guys, I said, you didn't find any prints on that tarp, did you? Now, I like the way the state tries to cover some of these lack of evidence up. Okay, I really kind of got entertained by it at a point. They'd say this, well, you weren't surprised, officer, that given the evidence was degraded that you couldn't find that, could you? No. And I'd say this, hey, what do you mean degraded? The evidence may have never been there in the first place. It could have been degraded when it went into the ground and evidence was put on it prior. How do you know the condition of the item before it went in the ground? But they had to acknowledge that, yeah? So the state would repeatedly, to try to cover up the lack of evidence, well, you're not surprised at this. It was all degraded. You wouldn't expect it to be there, would you? No, no, no. So that's how they try to defend themselves against the lack of evidence. We saw that repeatedly in this trial. Now, we heard with regards to the TARP, the state never investigated it. One, party with the burden of proof. Two, we heard Laurie and Isabel both take the stand. We didn't have one. We didn't have one. Now, that logically goes with the theory that that body had been off the ground, off that site, because it comes back to the property and it ends up in the gravesite. Can we assume that Mr. Townsend put that in there with the straps, wrapped it up, took it off-site, damaged the body, brings it back and puts it in the grave? That's a logical conclusion. I asked the investigator, I asked the tech people, listen, were there any telltale signs on that tarp that tarp had been dragged across the yard? Huh? What do you mean? I said, did you ask for any kind of chlorophyll testing underneath it to see if it had been dragged by somebody? No. You see? Do you know if Laurie took it out there? I don't know. Do you know the distance from the house? No, we don't. Somebody else can tell you that. So what does the state do? They offer some evidence showing she's working out, and you're just to jump to this conspiracy theory and say she could have dragged it out there? She could have done this? She might have done this? For you to fill in the gaps that the state failed to investigate? And that's what we see in this evidence thrown in your face without a real connection? You look at the forensics. I brought out, state didn't do it, the defense brought it out. There's no DNA in the house, no evidence of how the crime occurred in the house, no prints, no hair analysis, yet there were hairs, okay? No match of any flooring that was found in the gravesite to implicate Laurie Shaver. Those all create a reasonable doubt. The state can't ignore it. Instead, they just want to say she lied about this or she lied about that and she's sleeping around. That's their case. That's the state's case. Now think about the gun we heard about. We have a gun in evidence. Again, kind of a comical display to me. You get this lady up there, and she goes through this litany as to her experience and everything. And she talks about, well, it has the signs of other guns, meaning this manufacturer that make Colt or Smith & Wesson that may manufacture a .38. They got a machine. It's going to have ridges in it. They all have that common characteristic. Millions of them, okay? But she can't identify any specific features of the gun. She can't narrow it down from millions to say it's this gun. Wow. Wow. So the state says it can't be excluded? No, it can't be excluded. Right. That's reliable evidence for you to hang your hat on and to fill out a verdict for the state? No. The state's position is, well, we don't have to prove this case by 100%. No, they don't. Okay. That's not the requirement. We know what the requirement is. When Jeremy Townsend, the state was informed of Jeremy Townsend, why, ask yourself, didn't they look into his financial records? Lack of evidence. 2, why didn't they look into his Facebook aside from his banking? Do you remember what the testimony was on that by Tamara Dale? Here's what she said. Well, those records were too old. What do you mean they're too old? You're going to stand in here and tout that Laurie Shavers are reliable at the same period of time and not look into Jeremy Townsend, who you've been advised shot the guy? And not even look? Not even look anywhere into his matters? No. She was closer to the body. Okay. Now, let's talk about the patio. State thinks that's a big deal. I don't. Why? Because they had cleaned it out to make a pond. We all know that. Okay. They get tired of building this pond, and it sits for a while. Concrete is bought. Now let's think about that. Nobody goes and tries to conceal themselves when they're buying any concrete. They don't go paying cash. They don't go in there with a hat on or anything like that trying to disguise themselves. It's open and clear. They're not trying to conceal themselves. They go rent a mixer, not trying to conceal themselves, not trying to make it private, or a hidden event. They even post it on Facebook. Like this is a big secret? No. No. Who would do that if they're trying to hide a fact against the public and knowledge? You wouldn't do it that way. That's just common sense. Okay? You take the evidence and then you rely on your common sense or the lack of evidence thereof. That's the point. Who would write their name in concrete on top of a grave of somebody that they allegedly murdered? Not any person in the face of this earth would do such a thing. You got to admit that. So you see, there's another reasonable doubt the state can't account for. We had Holcomb, officer, take the stand and said, oh, it was right in the middle. Okay? Like it was obviously trying to be concealed. It wasn't. When I pressed her on the video, she said, well, it wasn't on the middle, actually. Then the next officer said, well, it was a darkened spot. And you look on the photos, well, there's about 3 or 4 darkened spots all over the place. Okay? Doesn't mean, we know there's a body on there. There is clear evidence of guilt or anything like that. I want you to think about all those things that create a reasonable doubt. There's multiple, and the state can't excuse that. They cannot excuse those factors. There's a question, who killed, actually, Mr. Shaver? We know there's shrapnel. We know there's one fragment, but the shrapnel could have been a second shell. We know that from Shaw himself. Has the state eliminated self-defense? No. No, they haven't. Who has that burden exclusively and only? The state. We know this is a violent man who most likely didn't have a right to even be in the house. Is there evidence that the body was moved? Yes, there is. Has the state refuted that? No. Why no forensic audits? None. Now again, the state is looking for a verdict on something. Give me something. Give me something. So they got lessers, a primary, and an accessory. You have to understand, if Laurie Shaver's not guilty, she's not guilty. Don't be pulled into an emotional game trying to compromise, thinking you're doing justice one way or another. You have to understand that. Laurie Shaver's not guilty of any crime. She has not committed a crime. The state has not refuted it through an investigation and presentation of evidence in this case. Again, I'll remind you with regard to the crime of accessory, it must first be established that a crime was committed. If there was a right to self-defense, no crime has been committed. You see? and there is anything that Laurie Shaver did was lawful. The state can't link up any transaction unjustified or evidence of a cover-up if there is no crime that is committed. Likewise, the crime of accessory must establish a firm timeline as to when the crime occurred. You're not at liberty to say, well, the state says this and Laurie says this. Let's just pick a number. Could have happened between this date. The court will instruct you that that accessory requires the completion of one event before the start of an accessory offense. Okay? Has the state firmly established that? No. What they do is they say, well, there is, he didn't show up at work, so you gotta assume that she murdered her. And then let's take the next step and say all this stuff was to aid or assist in concealing an offense versus living expenses and money that she had a right to touch and use. An accessory, when you see accessory, normally what you would see is somebody buying somebody a flight ticket to leave town, putting them in private housing, doing things to conceal them in that manner. Not living like this. It kind of reminds me, this case, when I listen to it. It's all speculative, what you call circumstantial evidence. I'm sitting here listening, sitting at my table, between approaching the bench, I guess, and listening to this, and I'm going, it's like playing a game of Jinko. Sooner or later, this thing's got to topple. You can't just keep putting little boards on top of each other without a firm foundation, you see? It's not going to stick. So the state just piles up some evidence and says, there you go. Come back here, reach us a verdict, okay? Give us what we want. Now again, I remind you, and I'll sit down, leave it to you. The people that may have been misrepresented, the people that any lies or misstatements were given to, really are not relevant in this case. Laurie's not on trial for lying. She's on trial for murder. Any misstatement must have been to make and conceal a crime which never has occurred, you see. If she lied about Michael, where he was or what happened or where his tools were or where he'd been, is not really relevant in this matter. So don't be distracted in that regard. Going back to the digital data, I'll leave on this. Remember, I asked these witnesses, did you find anything in the digital data that announced or indicated somebody had shot anybody? No. Did you see any evidence in the digital data of any effort to conceal a crime? No. Could you tell me where this was coming from physically? No. Could you tell me who was using the device? No. So what did we have? I found it, I don't want to say it, but we get memes thrown in front of us and some emails from this place to that place, and you're supposed to say, let me hang my hat on this meme. Sometimes you got to burn a bridge and move on. That means Laurie Shaver killed somebody? And that's what the state is asking you to hang your hat on and just pile up a bunch of memes like a Jinko game? No. That's not how you prove a criminal case with suspicion, bare innuendos, without physical evidence of guilt. Now you have, likewise, and I mentioned it to these people on cross, I said, you got a certificate over there, a business record certificate from Facebook, right?
I'm gonna object. Can I approach?
Sidebar, please.
Business record certificates from Facebook. Really interesting. I brought it out on cross-examination. I mean, kind of floored by it. But here's what they say. In essence, read them yourselves. Well, we once had this data. We gave it to you earlier. We're sure we gave you something that was accurate, but we don't have the information anymore, so we gotta just assume it was accurate. Okay? That's what the state's gonna hang their hat on and say this digital data is even reliable for your consideration? That's not even digital data. And we know what Connor said. You can't even link it up from this place to this place because IP addresses have expired the physical location, and the state's hanging their hat on it to throw all this out there. It's unbelievable. Further, the state doesn't even have a computer. There's no computer in this case. Not a computer for them to try to connect it to. I want you to think about these factors. This is where, ladies and gentlemen, my power ends. This is where yours begins under our Constitution. I can only ask, I can only beg you to do your duty. Don't compromise your duty. I've listed to you multiple reasonable doubts in this case. They should never be compromised by any single one of you. I asked each and every one of you as well to please hold your verdict, and if it disagrees with other ones on this verdict, on this full jury, that you please hold your ground. I've shown you everything, every way the state has failed in this cause. Don't be misled, I ask you. The state will have the last word in this case. They always do. Wasn't like that always when I practiced law, but it is now. But as Mr. Camuccio speaks, I ask you to listen. Give him the due concern that you've given me. But I ask you to ask yourself, as he speaks, what would Mr. Wiggs point to refute that? Have you answered Mr. Wiggs's questions? What about this question? What about the grave? What about the lack of evidence? What about the gun? Let's hear an answer to all these things. He can't give you an answer. So I ask that when you go back there, I know the answer, which should be given by you, but I can't do it. But I ask you to do the right thing and come back on all counts, all issues, and do justice, not seek a verdict for the state. Seek justice, as I've asked, and return a verdict on all counts of not guilty. Thank you.